The Supreme Court's ruling this week allowing the Trump administration to proceed with mass federal layoffs highlights a worrying pattern. America is increasingly governed through emergencies rather than deliberate procedure and regular order. The shift toward governing by crisis, or perceived crises, is seen across multiple branches of government and raises serious questions about the health of our democracy. At issue in Trump v. American Federation of Government Employees was an executive order the president signed in February directing a large-scale reorganization and streamlining of the federal government. After a lower court temporarily blocked the policy, the Trump administration bypassed the standard judicial appeals process and requested emergency relief from the Supreme Court. This week, the court granted the request not by thoroughly considering the merits, but by simply declining to pause the layoffs. And yesterday, the State Department informed employees layoffs were imminent, with other agencies likely to follow. Such rapid, opaque judicial action was once unusual but has now become routine. Traditionally, most cases that come to the court via its merits docket have been fully vetted by lower courts, and when the record of those decisions arrive at the Supreme Court, it takes months of scrutiny, detailed briefs, oral arguments, before we get the justices' reasoned opinions in writing. Trump v. AFGE bypassed all of that, appealed to the court on its emergency docket. It was just a matter of weeks before the justices ruled. As is common in these types of cases, the ruling was done largely without the benefit of the lower court's thorough and considered examination, written briefs, on-the-record oral arguments from both sides, deliberation amongst the justices, written decision, or a vote count. The use of the so-called shadow docket, which is hardly a viable descriptor now given the emergency docket is so widely used and no longer in the shadows, has increased exponentially in the last several years. This term alone, the court has already decided 111 cases on emergency, with more to come. That is more than double the number of emergency cases it considered last year, 44. Another point of comparison, whereas G.W. Bush and B. Obama went to the court on its emergency docket a combined 8 times in 16 years, Biden filed approximately 5 per year, and if the first 6 months are any indication, the Trump administration is on track to more than quadruple that. While genuine emergencies, such as imminent national security threats, natural disasters, or immediate public health and safety issues require rapid governmental response, many recent uses of emergency procedures do not clearly meet such urgent criteria. The Trump v. AFGE decision provides an illustrative example. Layoffs of federal workers, though politically contentious, hardly constitute the kind of immediate national crisis that necessitates bypassing standard judicial processes. Throughout the last term, Justice Ketanji Brown Jackson issued several powerful dissents in which she made this point, including once again this week in the Trump case. Jackson warned that the court was granting potentially devastating aggrandizement of executive power without sufficient scrutiny or justification. In her view, these quick, unreasoned decisions compromise critical checks and balances, ultimately hurting ordinary citizens. She underscored the risk clearly. Today, the court exercises neither caution nor scrutiny, she wrote, once again leaving the people paying the price for its reckless emergency docket determinations. Jackson's concerns reflect a broader scholarly consensus about the misuse of emergency procedures. Experts increasingly view the Supreme Court's expanded reliance on the shadow docket as dangerous precisely because it allows consequential policy shifts to occur rapidly, quietly, and without public deliberation, reasoned decision-making, or accountability. Yet, this troubling trend toward emergency governance is not isolated to the courts. Just days prior to the Trump v. AFGE decision, Congress passed, and President Trump signed, the expansive One Big Beautiful Bill, a wide-ranging legislative package affecting economic, regulatory, social, and defense policy. Most lawmakers received no meaningful opportunity to review the bill's language, let alone debate its detailed provisions, several of which were highly controversial. This is nothing new. For years Congress and the President have failed to follow regular order and used alternative means to fund the government. Governance via crisis or emergency is neither new nor unique to any one branch, party, president, or leader. It is a character of a system like ours that is so divided, not in the modern partisan sense, but rather in the old-fashioned, Structural sense. The American system was designed to make it difficult to get things done, regardless of who is in control. It was designed this way for a good reason, to protect liberty. The question today is whether the Madisonian system is still working to our advantage, and if not, what should be done to address it?